Mr. Nunley?
Good morning, ladies and gentlemen. 7 aggravating factors set out in the Florida statutes are applicable to this case. You have heard a fair amount of evidence in the guilt phase of this trial that carries over into the penalty phase and goes to wholly or partially establish some of those aggravating factors. Some of those aggravating factors you've not heard about yet, but will shortly. The first aggravating factor that the state believes applies, that you will find beyond a reasonable doubt, is that Mr. Nelson has previously been convicted of a violent felony. We will present evidence to establish that. And during Mr. Nelson's testimony, you heard that he was on felony probation. You will also see, in connection with the same evidence establishing that prior violent felony, that he was in fact on probation at the time that he murdered Jennifer Fulford. You heard during the guilt phase in Mr. Nelson's statement that he killed Jennifer Fulford so she would not testify against him. Those facts establish beyond a reasonable doubt the avoiding arrest aggravating factor, which is that the murder was committed for the purpose of avoiding arrest. He did not want Mrs. Fulford to testify against him, and he told you that in his statement. Also, in his statement, we know that Mr. Nelson committed this offense for money. There is no question that Jennifer Lynn Fulford died because Mr. Nelson wanted cash. That is referred to in the Florida statutes, and you will hear it described as the pecuniary gain aggravating factor, that the murder was committed for pecuniary gain. There is no question but that aggravating factor exists beyond a reasonable doubt. By virtue of your verdicts last Friday, finding Mr. Nelson guilty of robbery and kidnapping, you have established beyond a reasonable doubt the aggravating factor that the murder was committed during the course of a robbery or kidnapping. That aggravating factor has already been established and is proven beyond a reasonable doubt. During the testimony, and moving on to the next to last aggravator we're going to talk about, you heard testimony from the medical examiner, and you heard testimony through Mr. Nelson's confession to law enforcement about how Jennifer Lynn Fulford was terrified, was crying, was begging for her life in the 1-hour drive he took her on from Reed Berman's house in Winter Park to the shadow of Epcot Center. Based upon the cell phone information, we know that was about an hour that Jennifer Lynn Fulford was restrained in the cargo compartment of her own car. These facts, coupled with the medical examiner's testimony, go to establish the aggravating factor that the murder was especially heinous, atrocious, or cruel. Now, let me digress here for just a minute. The conjunctive here is or. It is not heinous, atrocious, and cruel. Each one of those terms means something different, and each one of them will be defined to you by the court. It can be heinous, it can be atrocious, or it can be cruel and still establish that aggravating factor. The heinous, atrocious, or cruel aggravating factor goes not only to the manner in which Mrs. Fulford died, but also to the terror that we know from Mr. Nelson's own confession that she endured before he took her out of her car on Fenton Street, took her through the tree line, took her into a field, wrapped duct tape around her head to the point that she couldn't breathe, and stabbed her 7 times. Those facts together established beyond a reasonable doubt that the murder was especially heinous, atrocious, or cruel. The final aggravating factor that the state will submit to you is that the murder was cold, calculated, and premeditated without any pretense of moral or legal justification. I think we can dispense with the moral or legal justification component of that aggravating factor already, because there is none whatsoever that exists. The cold, calculated, and premeditated aggravating factor uses the conjunctive and. We have to establish that it was cold, that it was calculated, and that it was premeditated. And those terms will be defined for you by the court. What we have in this case is a murder that was committed after the planning of it began some 2 weeks before, with the purchase of various items at a Walmart. We know that Mr. Nelson bought duct tape. We know that Mr. Nelson bought long zip ties, not the little short zip ties, but the 18-inch long zip ties, and a 4-inch long folding pocket knife. And as my colleague said in closing argument, maybe we can give him the knife. But the duct tape and the zip ties comprise parts of a murder kit, and that's all there is to it. That is cold, that is calculated, and that is premeditated preparation for this murder, even though Jennifer Lynn Fulford may not have been the target of the murder at that time. But that doesn't matter for the aggravating factor. You will hear additional evidence. You will hear a description of, from his statement, what went on out on Fenton. You know what happened out there. The terms of the coldness aggravator will be defined for you. That aggravating factor is also established beyond a reasonable doubt. Also this morning, and today, you will hear what is referred to as victim impact evidence. Victim impact evidence is evidence designed to let you know, if you will, the loss to the community as a result of Jennifer Lynn Fulford's murder. You are not to consider victim impact evidence as any sort of aggravation. Let me say that again. Victim impact evidence is not to be considered by you as an aggravating factor. It is offered to establish and to show you Jennifer Lynn Fulford's uniqueness as a human being and the loss to the community from her death. I expect the defense will present mitigation evidence. And depending upon what mitigation evidence they ultimately present, the state will have the opportunity, if we choose, to present evidence in rebuttal of that mitigation evidence. Y'all have been extremely attentive thus far. I know it has been a mentally taxing and exhausting process. I'm going to ask you to keep it up. Pay close attention to the evidence offered in aggravation. Pay close attention to the evidence offered in mitigation. And when you weigh the aggravation against the mitigation, I suggest that you will come to the conclusion that death is the appropriate penalty in this case. Thank you.